Well, having said that the FINRA arbitration forum is less expensive than being in court and generally a more simple process than being in court, and I would consider those benefits as opposed to being in court, overall it is not as fair as being in court. One of the first things I tell a new client is we're in a system that is not fair to us on our side of the fence. The system was set up by Wall Street. The system, that is the Wall Street firms, basically pick the arbitrators. We have some input into who they will be, but for the most part, they are selected after a very arduous process by the industry, not by us. And so we're in front of their judges. And when you put that in the soup, it really makes for an unfair process. But the other thing I tell them is, it is what it is, and we're stuck with it. The United States Supreme Court found this system in 1987 in the case of Shearson v. McMahon to be fair, to be a system that allows investors to recognize their fundamental rights to due process and such. So they've declared it as fair, and although I and plenty of other colleagues of mine feel it's not exactly fair, we are stuck there, and so we do the best we can. And that's why it's really important to select a lawyer with a significant amount of experience in the industry and in that system in moving a case forward.